Greetings, class. This is week 8 of contracts. This is the last and final week. And congratulations to you on making it through the first 7 weeks. I know it's a lot of material. You guys have done great thus far with the material, and I hope that you have enjoyed the class. Now, as we're on to the last lecture, I would be remiss if I didn't say, go to Blackboard, go online to the course content section, go all the way down to week 8. There you're going to find a discussion board for this week. Make sure you reply to the discussion board prompt this week. If you watch this video lecture, you hopefully will have the answer that you need, and you can chime in with some of the other materials. The second thing this week, you're going to see some PowerPoint slides. Download those slides, track along with us as I give you this lecture and discuss some of these concepts. All the way at the very bottom, you're going to find your final exam. The final exam is due Saturday night at midnight. Make sure you give yourself plenty of time to answer those questions. It's a multiple choice question test that works the same as your quizzes and the midterm. So good luck on that. Let's jump in here to the final week. And by now, you've got an enforceable contract. It doesn't have any validity problems, and we know exactly what the parties were to do. That was last week's lecture. And now we know what they were supposed to do. All the conditions are met, and there are no defenses. That particular person didn't do what it was that they were supposed to do. So what happens next? Well, there's a breach of the contract. And a breach of a contract is basically where the law gives a remedy. A remedy is meant to compensate the non-breaching party for the breaching party's consequences, what they set in motion, their actions. This is an area of contracts that distinguishes it from other areas of the law, say torts, where the remedy in torts are to look backward and put the person in the position he was in before the injury. Contracts looks forward, and they say they seek the place of the non-breaching party and put them in the place that they would have been had the breach never happened, had there been performance. So put it another way, the law of contracts looks at what the non-breaching party reasonably expected and then tries to fashion a remedy from that perspective. Now, it's almost impossible to put get the mind of what that particular person expected and put that into practice. So we've got a lot of rules that govern that, and that's what this lecture is going to be about. This week, we are reading Chapter 8. Chapter 8 has various lessons, the beginning of which asks various questions. When is a party entitled to actual performance? When do you get what you bargained for? When instead do you have to settle for the money damages that it would have been that you would have received? And can you actually contract with somebody ahead of time what your damages will be in the event that somebody actually breaches it? To kind of predict it. Lesson 39, as you track along with the slides, talks about specific reliefs available. For instance, we're going to talk about the remedies, and their overview. As you overview the remedies, we're going to begin studying about the terms cancellation, avoidance, termination, all of which are discussions from last week. I'm not going to give specific talk to. We talked about expectation damages at the very beginning of class, and expectation is that remedy that entitles the promisee to be placed in as good a position as if the contract had been fully performed. Normally, that is the ordinary legal remedy in contracts. But before we talk about that, and taking the slides a little bit out of order, let's talk about specific relief, or what others refer to as specific performance. Specific performance is a special remedy. You know, it might seem that the best way to place somebody back in the position that they would be had the contract be performed is just make them do it, right? That makes sense. I agreed to mow your lawn and I don't. Well then, as a consequence of the breach, you're going to force me to mow your lawn. Well, that would be easy. That would be simple. But that's not constitutional. The historical and constitutional reasons Americans, under the common law and courts, rarely resort to ordering a breaching party to do what was promised. That would be involuntary servitude, right? it would be inadequate, and equitably it would not be fair. There are, of course, some exceptions. So, back up, specific performance, or ordering you to specifically do what it was that you contracted to, is a special remedy. Okay? It is the rare remedy. The most usual remedy is that which you can measure in money, the losses that were incurred in the breach of money and money damages. Most cases, therefore, the issue of specific performance is not available. So, what is specific performance? Well, it is circumstances in which you actually do order the party to do what it is that they said that they were going to do. All right. This is only available as a matter of equity, fairness, right? In circumstances in which money damages would not be good enough, would not be adequate. For instance, real property. There's only so much earth around. And that earth, that land, it might be worth something, but it is specifically unique. So if you agreed to buy my land and then I agreed to sell you my land and then I breached that contract, well, you could be entitled to specific performance because land is unique. Additionally, for the sale of goods that are rare or indispensable, irreplaceable items of personal property, such as famous paintings or a rare car or rare books or unique handmade clocks, something like that, well, the law says that there is no adequate remedy at law for goods that have this specific, high quality, irreplaceable value. A court can, in those rare circumstances, order a decree of specific performance in equity, saying that it is fair, to force the sale or force you to live up to your side of the agreement. It's all based on the circumstances of fairness. All right. Now, in transactions of goods under the UCC 2-716, require that the goods be unique. Its uniqueness makes it subject to specific performance. Unique goods and other proper circumstances are the only way we get to that in goods, and it's covered in our slides in our book. All right, let's move on to Lesson 39. In Lesson 39, we talk about what it is that is the expectation damage, the general measure of money damages, right? America's common law system prefers money damages to any other remedy for a breach of contract. In other words, the court will value the breach and substitute it for money as a damage or remedy. As a result, most courts and most contracts cases, remedy, ask questions to explore the calculation of these damages. Now, I will tell you, as a preliminary matter, we're talking about math, we're talking about formulas, we're talking about numbers on a sheet of paper. I am not your guy. My dad's an accountant. I said at a very early age, I am going to go to law school so I can avoid math. And here we are talking about math, right? It's a calculation of damages. And Lesson 39 goes through some of that. I actually provides you a formula in Lesson 40 as well, the seller's damages. There's a nice chart or a graph on one of the slides here that has Formula A and Formula B. There are a couple different formulas to calculate damages. And you look to the Restatement Second of Contracts, Section 347, to find out when and how much the seller is entitled to money damages. That amount being the loss in value that the seller caused the breach, plus any other loss, which would be incidental or coincidental losses caused by the breach, minus any cost avoided or losses avoided by performing. Now, even for non-math guys like me, you can pretty much figure out what this is. The formula is pretty simple. If we were going to have a contract, let's just say for the sale of a whole bunch of rare baseball cards, and the rare baseball cards were worth a certain amount. The loss of the value, and you breached it by not selling me those cards. The loss of the value that the seller caused, that you caused by the breach, would be calculated. That would be one number on the sheet of paper. Plus any other losses or incidental losses that I lost as a result of your breach. For instance, I was going to sell them in my baseball card shop, and I had all of these outside costs by advertising and stationing and getting everything ready for the cards to be shipped. I incurred a whole bunch of losses or costs to myself. Those are incidental and coincidental costs. And then, let's say you called me up early and said, stop the presses, we are done, I'm not going to be able to deliver on the contract. The costs avoided or losses avoidable by not performing. I didn't go through the expenses of having all of my lights on for the week. I was going to sell those cards in my store, so those are going to be minused or subtracted from the value of what it is that's been lost. Basically, expectation damages protects the value of what the parties reasonably expected to get through full performance of the contract. And there's different ways to measure it. I've just given one. It's the difference in value of performance. There are some cases, for instance, the Hawkins versus McGee hairy hand case. I encourage you to read that if you haven't already. And ways to measure the benefit of the bargain are also discussed in lesson 40. It's that calculation or formula of the specifics of what you would have gotten in your project. I'm going to kind of run through those as fast as I can. There also is that duty to mitigate, which is also discussed in lesson 40. Mitigation is basically where you have a duty as somebody who is aggrieved to try to make your losses as short or small as possible. So for instance, I know you're going to breach. I can't go up there and rack up my costs knowing that I'm going to get remedy or reimbursed for all my costs. At the moment that I know that the breach is going to happen, I have a duty to limit my damages or mitigate my damages. There's a couple different kinds of mitigation. There's passive, where essentially the seller can't run up the costs, right? And active, where I have to affirmatively take steps to reduce the losses that may be incurred through your damage. For instance, selling off or putting to use those unused materials. Think of that in terms of you're building a house and all of a sudden the party breaching it says, I don't want the house anymore. I've got all this lumber. I've got to do something with it. I've got a duty to try to mitigate or actively sell that stuff to somebody else who can put it to good use. I can't just leave it out there in the rain to mold and to wilt and to have damage done to it. The damage formulas are A and B, the loss in value minus the cost avoided plus other losses minus losses avoided. Profit plus actual cost plus actual loss minus loss avoided. There's the formulas there. All right, lesson 41, as we jump into that, we're going to talk about other damages, special damages, coincidental damages. These are damages or coincidental losses that arise from events that are not directly subject to the contract breached, as distinguished by direct losses, but nonetheless happen as natural consequences of a breach. Coincidental losses naturally occur, right? And these are damages to a person or property, including personal injury as a result of a breach of contract. It is the incidental financial loss in a commercial context that I've already talked about. And our slides talk about how, just as I've already talked about earlier in this video, that you've got a duty to try to mitigate, and damages have to be limited to what is foreseeable. We talk about the Hadley versus Baxendale case there, the classic contracts case. Finally, let's talk about the last little bit, and that's I'm going to skip all the way to lesson 44, which has to do with liquidated damages. Contract law is a law of consensual obligation. What does that mean? Well, that basically means the parties agreed to be bound together in contracts, so the parties have to abide by the terms that they deal with. They are together by design, and so thus they are defining the terms of their legal duties to one another. Therefore, it's logical that they could also say, in the event that I breach this contract, this is going to be what damage I will pay to you. That's called liquidated damages. Now, there's a big difference between liquidated damages and penalties. Penalties for non-performance are not allowed in contract law. You don't do penalties. Punitive damages is something that you get in contract law, in tort law, not in contract law. Instead, you can actually liquidate. You can actually say, I'm going to agree to do this. So thus, your liquidated damage clause in your contract is going to be enforceable provided that it is not seen as a punishment. It's not seen as a penalty. There's some different rules there. You'll look at those rules in 2.718 of the UCC and 2-302. There's some limitations there regarding the liquidated damages clause in your contract. Okay, I've kind of skated through that pretty quickly. It is a topic that you could probably spend half a semester talking about. And here, I talked about it in 16 minutes. Hopefully you didn't spend more than just 16 minutes on it. You actually read the book and looked through all of those examples. If you got specific questions, as always, feel free to post those in the questions section of Blackboard. And let's talk about this topic a little bit more in Blackboard and answer this question. This week, as we're discussing breach of contract, you are asked, why does the law prefer some remedies over others? And in what ways can you force somebody to perform or do what it is that they've actually agreed to do in a contract? That's discussion board topic for the week. That is week 8's lecture. I hope that you have enjoyed this class. I hope you've enjoyed this lecture. And let me end by saying this. I have thoroughly enjoyed being with you throughout the semester. I know some of these videos have been long, and I know I've talked fast in some of them. So I apologize if some of the material was glazed over like today's topic, but you get the concepts. That's the purpose of the videos. I hope you've enjoyed them. As we finish the semester, I want to say and end with this note. 2 things. If you ever find yourself in Wise, Virginia, drop by the courthouse and see me at the Commonwealth Attorney's office. If you don't find yourself in Wise, reach out to me if you ever need anything. It has been a pleasure to work with you this semester. I wish you the very best in the final exam and also all of your future studies here at Regent University. It's been a pleasure to talk to you, work with you, and I look forward to seeing great things as you are now going to take the motto of Regent University to heart and become those Christian leaders changing the world around you. Good luck. Have a great day.